Okay, welcome to today's CCPL Center for Comparative and Public Law Talk. My name is Jindal. I'm the director of the CCPL, and it's my great pleasure to introduce our speaker today, Professor Wenjuan Zhang, who's the Professor and Associate Dean of Jindal Global Law School in India. So Professor Zhang is a law graduate of Columbia Law School and also Peking University Law School. She's also the Asia Fellow of Harvard Kennedy School in 2021 to 2023, and hold a Mark Haas Fellowship with the Brennan Center for Justice at NYU School of Law in 2015, and also a visiting scholar at Yale Law School in 2012, and also hold the PillNet Fellowship of Columbia Law School in 2006 and 2007. And before Professor Zhang joined the Jindal Law faculty, she actually served as the vice director of Zhicheng Public Interest Lawyers. For those who know about public interest law in China, and this is one of the most influential public interest law firms based in Beijing. So Professor Zhang has herself worked as a public interest lawyer for many years, and her research focused on comparative governance studies in India and China, and mainly around constitutional law, lawyering for change, civil society development, and child law. And today I'm very pleased that Professor Zhang will be talking about a very important but underappreciated topic, which is the legal education system in India. Because as someone who studied the Chinese legal system, I always think that comparison between China and India in terms of the legal system, legal education, legal profession is an extremely important topic. But there are actually very few people, and I think Professor Zhang is probably the only one who actually has the expertise to actually talk about the legal system in India, also compare with the legal education system in China. So without further ado, I'll turn the floor to Professor Zhang. Welcome.
Thank you. Shall I start?
Or up to you.
If I start,
it's fine. It's fine.
Okay. First of all, I want to thank all of you taking your precious time to be here. Actually, this is my first time to come to Hong Kong after the pandemic. So I'm very excited to get reconnected with these old friends, Professor Fu and Professor Liu, and all of you and the new friends. I have been to India for this is the 10th year. So I joined the Jindal Global Law School in 2014. My vice chancellor told me I should be, or I think I might be, but he said I am the first Chinese the Chinese law school faculty, even the university level. The higher education sector. So I'm the first Chinese to have the full-time position in India. So this gives me a very kind of special platform to engage in India daily life and professional life. I benefit a lot from learning from my colleagues, especially the founding vice chancellor, Professor Siraj Kumar. So I will share with you, briefly introduce the India legal education. So I would remind you of this kind of 6 angles for you to look at the Indian legal education. For example, the pre-independence history has a huge impact on many issues, especially for the legal system of India. But for legal education, actually the impact is not that big. I will explain why. The second is we need to understand the judicial role, the Indian constitution and the judicial role for understanding Indian legal education. And the third is we also need to understand the higher education governance structure. It's complex. Before the lecture, before the talk, Professor Liu talked to me about this, how to understand the Indian law schools. I said there are 3 generations. It's mainly kind of, caused by this complex. They try to navigate the space for moving forward. The fourth is the reform initiatives. I'll give you 2 examples. I will call them the 2.0 version and the 3.0 version. Of course, economic liberalization in 1990s and the globalization also play a great role in reshaping the Indian legal education. So for pre-independence, you might know that the British colonizer actually have been divided into two stages. One is the East India Company. So that's the between 16 to 1857. So because it is a company, the administrative power actually is not as the British India, the later stage. The British, they call it British Raj stage. So from you can see the first they got, even though during the British the East India Company stage, they set up the mayor's court to mainly to deal with this kind of a transaction disputes and something. But later they expand to the local residents. In 1974, they tried to expand. I would not use the term scale up because different cities have different systems. So until 1982, actually, India High Court Act authorizing the big cities to have the High Court. So you know the Indian legal profession, the lawyer, mainly kind of is up to the High Court. All the rules set up by the High Court. The High Court are actually very decentralized. So that's beside India's legal profession and legal education very decentralized or even fragmented before the independence. The legal education also, you will see the Bengal Regulation 7 actually is the first to authorize the legal profession, or you may see allow the local the appeals or the native pleaders to show in the court by after paying some money. So in terms of the universities, actually, it's also set up by the expansion of the colonization. So in 1857, they set up these 3 universities. Later, they call it the first law college actually in Bombay. So sometimes they use Mumbai and Bombay because Bombay is a colonized term and Mumbai is later changed. You will find in India many cities' names have been changed. So Bombay and Mumbai is one of them. So the first law college they said is established earlier than the university, but later affiliated with the Bombay University. So the university is also kind of fragmented or scattered from one university to more, but they don't have they are not kind of well connected or have the uniform standard. The legal profession also subject to the different high courts, also kind of fragmented. So for after independence, so their first task is to develop a uniform standard legal profession. And there are many reports, but I would remind you, if you have the research interest about the Indian legal education, these several reports you need to read. It's very important, which laid the foundation for the legal education report. The first one is Radhakrishnan Commission report. So that's on higher education, but it had some knowledge, had some reminder of the education also. So it's talking about legal education. What's the position or the nature of the legal education? So before it's really kind of vocational, but in this report it says legal education, the nature should be both liberal for scholars and vocational for professionals, for practitioners. The second is the Law Commission of India, the 14th report. It's mainly about the judicial reform. You might know that the Indian Constitution actually set up a uniform or single judicial system different from USA. So it's a uniform or single judicial system. So they also have reformed this kind of a judiciary structure, right? And that have lots of recommendations for how to establish the Bar Council of India and how to regulate this legal profession. So the kind of the debate also about it is up to the court or up to a new established professional council. But later the National Knowledge Commission and Supreme Court of India and also the There are different reports. The most recent one is the National Education Policy 2020. I don't know whether you have heard. If you want to observe in India education reform, so that's a new blueprint under the Modi government. There are lots of new changes. You know, in India, there are initiative is called the Eminence of Institute of Eminence, to give public university, top 10 public university, top 10 private universities for the experiments. So the 10 public universities can get more funding, like the IITs you have heard. And the private university give more autonomy, like they will be exempted from this kind of policy burdens. So GGU actually now is one of the private universities to get the IOE. And so we are experimenting some new ideas of the national education policy. So 1947 to 1960s, you will find the new constitution, as I mentioned, is a quasi-federalism, right? So uniform judiciary and a least-based center-state relationship for the legislative power. Many of the scholars says it's federalism, but if you look closely into the system, you'll find it's a quasi-federalism, as I explained. It's a uniform judiciary, and also for the legislative power, the residual legislative power is with the center, not the state. It's different from the US. And also, in terms of the education, they have the 7th schedule, they have the list, the unit list, the list 1, and list 2 is a state list, and they also have concurrent list. So for the education, higher education, the entry 66 of the unit list. So that's the UGC's. I think in Hong Kong you also have a UGC, University Grants Commission. So that supervises this kind of the whole university structure, but not as a real kind of regulation body with a strong power. For the technical or vocational, they also have this kind of let's see, like different professional associations, the Bar Council of India, for legal profession. So the governance structure actually, after the independence, the Redaction Commission report suggests that's the nature, right? So you should not just let a professional training or vocational training, you should add a university for liberal purpose also. And then the Law Commission, the 14th report says, we don't need, because Ambedkar is very, you have heard of Ambedkar, the name? Ambedkar is called the constitutional father. So drafted the constitution of the Indian constitution, very influential. Actually, Ambedkar suggests to have a separate committee to supervise legal education. But the 14th report says, not necessary. So parties for university like UGC can supervise, part for professional training, PCI can supervise. So no need to have a separate committee to supervise legal education. So then later this has been adopted. So the Advocate Act 1961 gave BCI, Bar Council of India, the power to supervise the professional part, to set up the minimum standard. And then the UGC to supervise the university, the course design, or all these things. But you will see, if you look at the UGC, it says there's something you can mention. So UGC needed to coordinate with the universities for the supervision. And then the Act, the 7I, this article, is actually saying recognize university whose degree law. That means whose law school's degree can be admitted for legal profession, right? Profession. So both of them not very, seems clear but not clear. So from 1950s to 1970s, none of them figure out how to move forward the regulated legal education. So the legal education is still in a very poor quality. And then the 14th report said it's extremely defective. And then later, the many reports still use the similar term to frame the Indian legal education. And during that time, Ford Foundation set up the first office in India in 1952. And in 1954, Ford Foundation started legal reform in America. And they also want to bring the experience to India. So in 1955, we see we support the Dean of Delhi Law Faculty. That's the first generation of law school in India. And support that Dean to visit the US for 1 year to get the idea. And in 1956, actually, Ford Foundation financed to set up Indian Law Institute as a model for other law schools to reform. And then later, they also support the Chief Justice to have a committee to produce a report on how to reorganize the legal education. But, so that's also the tips for India reform. Sometimes see why you have a New Delhi. Do you know why? India, they don't call it New Delhi or Old Delhi. So it's a Delhi, right? But there's the older part, there's a Mughal, they have the older part, but the new part is established by the British. So New Delhi, and they will also have some other new cities. So in India, it's very, very challenging to reform the existing system. They have a very strong tendency. So Ford Foundation actually, I mean, the big lesson for them is to reform the existing system, like Delhi University. So they have millions of dollars and several decades of energy try to reform it. But in 1971, they have hired many kind of consultants to evaluate whether it's effective. I think the Stanford and several suggest. So, I mean, they said that it's not possible for Ford Foundation to reform the legal education. And then Ford Foundation make a big decision. I decided to end the program, shift it to agricultural reform in 1971. In 1971. Yes. So if you there's an article by an Indian scholar in Indiana University to talk about this whole process. So if you are interested later, I can share with you this kind of article. But I think the Indian legal education doesn't stop there. So there's moving on, there's reform. So that's the second direction. So this is the hero. They call the father of Indian modern education, Professor Menon. So I have met him several times. He has visited GGU several times. He passed away in 2019. So you see his experience. He went to in the Delhi University. So when the Ford Foundation promoted Delhi University for the reform, he was part of the Delhi University. And actually he visited Columbia, supported by Ford Foundation for 1 year. So after Columbia University Business Scholarship, he established the first legal clinic in India. And then he had been hired as a dean, it's called principal in Pandipuri, that's a law school. After he was back to Delhi, he had been invited by Bar Council of India to work as a full-time so there, you see, he combines different experience as a law school faculty, going abroad to have the new idea, and also already have served as a dean, and then he also served as a BCI, understand the complicated bureaucratic BCI system. So after these three, so he has the idea how to reform the Indian legal education. So his idea is that to study separate Indian National Law University and to start a new program, this program called BLB. So that means before Indian law schools, the first generation only offer LLB. So that's once you have a 3-year college education and then you can apply. So that's also rely on existing system, right? The LLB program. So because the legal education reputation in India is very poor, so they have very poor students to join the law program. So that's why, and so the poor students without poor, together with the poor faculty. So it's a kind of vicious, this kind of circle. So they cannot improve the education. And then he tried to break through from the existing system, so have a new law university, new program. So that's how National Law University succeed. At the beginning, when he proposed this, even the Delhi law faculty who has been supported by a Ford Foundation, objection on this. No, we won't have a BLB. We only have the LB. And then the Bar Council of India have a compromise, said if the university want to have a BLB, you can. But if you don't want, you can continue with the existing. So that's why the new university is so important. And he raised the funding. You see, there's 1 year back to USA to negotiate with the different stakeholders for get funding, and also negotiate with the state government called Connecticut. This is, I need to explain why it's so difficult or so necessary. Of course, it's necessary, but it's also difficult for the first national law university. If you look at the name, called a National Law School, right? It's called a law school, but also have an Indian university. So it's a university or it's a law school. Why they have such a complicated name is because in India, if you want to establish a university, you need to get the legislature to pass a specific law for that. So it's almost impossible to let the parliament, the national level parliament, to pass a law for establish this, right? So that's why this should be a state university. It's possible to mobilize the state legislature to have this. So it's a state university, but Professor Menon didn't want to be a state because it's not it cannot be that exemplary. So he needs to be a national. So put a national law school there is a law school, but it's also one university. So that's the combination. So if you cannot understand the Indian complicated system for higher education regulation, it's not easy to. So later, for the first one, because it's a model, so India, Bar Council of India give money, and Ford Foundation give money, and the state give money. So for later, there's a second one. So Professor Menon wanted to be a national phenomena. So if you just have one, maybe you just stop there. So he had to start the second one in Calcutta in 1998. So after that, the third, fourth, there's more. So you see the contribution of Professor Menon. First is bring legal education, clinical education to India. And the second, law university. So making the legal education similar to engineer and medical. And the third is to have the BLB. Now we have many BLB, BBLB, B science LB, many. But the most important is we recruit fresh high school graduates to join the legal education, not the LB to have the existing poor college graduation. The third is that till now there's 26 national law universities as a fast expansion. And in 2008, BCI have a new rule called that is a foundational rule for the legal education. So after the National Law University, BCI get the dominating rule. Before BCI and UGC both keep using, they keep using, but they don't know how to regulate the legal education. Sometimes they do something, some not. But after the National Law University, Bar Council of India is very progressive in regulating legal education, and they now play a very dominating role, not just the minimum standard. And through that, they also have extensive kind of regulation on this faculty, infrastructure, library, all these things. This had been supposed to be UGC's jurisdiction. So the third generation is this. This is the Vice Chancellor. Let's make the Indian legal education globalized. So he has a very global education background. Actually, it's the alumni here. So he used to teach at the City University of Hong Kong. So in 2009, he built the first private university in Haryana. And the first school of this university is a law school. His contribution is that internationalize of the Indian legal education. You know, before, as I explained, there's no ranking in India. Professor Siraj Kumar invited THE even to the president's house, the Indian president's house, to issue this kind of ranking publication to make it a high-profile event in India. And from 2015, Indian government also have their own ranking. They call that National Institution Ranking Framework. And so far, in there's two in the top 200, I think, for Indian legal education in the QS ranking law. So GGU in 84, and the National Law University Bangalore, I think around 200. So it's also bring LSAT. Like before, India's legal education admission is pretty poor, except the National Law University, they have a CLET. But the university you mentioned, National Law University Delhi, actually is exceptional. They don't accept that. They have their difference. And more important, which have been pointed out by other consultants or the policymakers criticize, is the research intensive. Most of the law schools don't focus on research. But GGU, GGLS actually have a strong focus on research. Let's see, in 2020 to 2021, GGU's publication in Scopus is more than the total of all the national law universities. So I'll show you that here. You see, we have 218 Scopus. It's more than all the universities, national law universities. Actually, I should congratulate to Raj. You see, CTU, University of Hong Kong, and OP Jindal, both ranking 84. That's the former. So if we look back, how Indian legal education. Hi, Sasha, my colleague, my former colleague. Do you know each other? Okay. So yeah, I think very important issue we need to analyze the background is the judicial activism in India, which promote the reform of the National Law University need some historical or cultural legal support. So that's the judicial activism in 1970s. So you may have heard that basic structure doctrine, as I explained, Indian Supreme Court of India have much more power than the US Supreme Court. First is the basic structure of doctrine. That means that we call it SCI, Supreme Court of India. SCI can hold that the constitutional amendment unconstitutional. That's very strong power. So it's not kind of original like this. The Constitution, actually, original design of Constitution is a parliamentary democracy. Actually, the parliament has final power, right? But later, it's from parliamentary democracy to aristocracy. So that's the Supreme Court has much more power. The first is the basic structure doctrine, and the second is actually is this, the collegium system of appointment judges. So like in US, the president nomination, senator approval, or whatever, this is a check and balance. But in India, it's the peer nomination. And then the appointment actually, to some extent, procedural. So that means the codified five committee. So you see that there's a three judges case we usually see. The first judge case, they get some power that says that the primacy of the Chief Justice of India can recommend the appointment. And the second case, it says the collegial system as the consultation. The Constitution said the consultation, but the Supreme Court says consultation is not you add the consultation, it should be concurrence. And the third case, it says the reference actually, but mainly decided by a 5-member committee. So the Chief Justice and several Supreme Court and High Court justice. So that means that's exempt India Supreme Court judges from the heavy intervention of the legislature and the executive. So that makes them much more independent. And in 1970s, they also opened the public interest litigation. You may have heard. The Supreme Court feel disappointed with the executive and legislative, and they become the main player of the front platform. Says, I want to save the people from the poverty, from the kind of a disadvantage. So just use the Article 21, the right to life. Expand the power of the Supreme Court. And today you will see in India, every people talk about what the Supreme Court of India have mentioned. So that's, makes the Supreme Court of India on many things. I remember during the pandemic, whether the government should bring the Indian citizens back. They also waiting for the Supreme Court of India to give the directive. So it's very interesting. The Supreme Court of India is everywhere in today's India. There's another background is the higher education system, as I just mentioned. So the Indian higher education has been developed I didn't mention it here in the PPT, but I want to explain here. So the Indian higher education, I said the 3 generations, right? The older generations, the modern university established by the British India. So they have the law faculty. The second generation is national law school. But the national law school can be approved in a very limited number. But there are many, in 1990s, India has the economic liberalization. So there are huge demand for legal education. And then many law schools, they want to establish, according to the Indian law, if you establish a law school, if you are not affiliated with a public university, you cannot give degree. So that means that they have to get affiliated with the public universities. And there are many, like the symbiosis, I don't know if you have heard of this, a very private, kind of prestigious private law school in 1970s. But until later, they have no independent status. They have to get affiliated with the China University. So later, only from 2000, I think the early 2000s, there's one new state. The Chief Justice want to collect the money and use the Constitution division. You remember I mentioned there's you see, 1825. So it's a concurrent list. So before, the people's perception is that to establish a university can only be approved by, especially private university. They wait for the national policy. And they have discussed this many times, but the law has not been passed. So many people waiting for the new law for private university, but they cannot get it. So they establish kind of law schools, or this establish colleges that get affiliated to public universities. But this new chief minister, because they call a factory, diploma factory, it's not a good case, but he opened the door for the private university. So later, all these kind of states realize they can pass the law, allow the private university. And that's how like GGU and many, the Bennett and Ashoka, the several new private universities. These new private universities is different from the previous like college, which mainly for money collection. So it's the extension of the business sector, the business investing in this kind of the new colleges to collect money. But for the after 2000s, there's new laws, this pilot allows state to establish private universities. So GGU become the first of Haryana, and there are several different others. These private universities have direct law schools, not the affiliated law schools. According to Indian law, private university cannot have affiliated schools. We have the direct kind of law schools. So that makes the Indian law school, especially globalized law school, develops very fast. So how much time I have? I should stop here.
No, 10 minutes.
Okay.
5 to 10 minutes.
Yeah. So if later, I mean, if you are interested in the legal profession, also highly related to this. So the Indian legal profession, mainly solo practitioners. I don't know whether here is mainly solo practitioners, family, kind of. So the corporate law firms, I think from late 2000s or so. So they have some studied abroad and try to, but still it's like 5% to 10% maybe. So that's, but in terms of globalization, this kind of new corporate law firms is creating incentive like for students to all universities. So now these Indian top law firms to come to GGU for the recruitment. And GGU to some extent also promote the policy, the discourse, public discourse towards this kind of a corporate style law firm. So we have created different international programs for our students. We like the globalized means semester-based exchange, joint degree, dual degree, and also we have this kind of joint publication. We encourage joint publication a lot, so that's why my colleagues try to work with you. So we encourage joint publication, but not with any Indian university, master university outside of India. So to some extent, I think GGU mainly has been benefited from the American legal education. Professor Kumar also, his idea about the law school actually produced in the NYU Law Library to discuss with the different US law professors. So I think maybe I stop here. We can have some more questions.
Yeah,